live on KSJE. This program is supported by San Juan Health Partners Urology, providing a wide range of personalized services for the whole family, including children. Our caring professionals are dedicated to helping meet your urology health needs with skill, experience, and service you need. For a complete listing of our services and to learn more, visit sanjuanhealthpartners.com or call 505-609-6300. San Juan Health Partners Urology, a division of San Juan Regional Medical Center. 8:38, 45 degrees outside our studios here at San Juan College, and winds are out of the east at 7 miles per hour. Our weather forecast calls for a partly sunny day on this Monday, 73 for a high today, 43 and partly cloudy overnight tonight, but then a change coming up tomorrow. Much cooler weather on Tuesday with a chance of rain showers, and 61 for a high on Tuesday. Maybe some rain and snow mixed Tuesday night with a low of 33, and then even colder weather for Halloween with a high of 56 in Farmington, and the overnight low Wednesday night down to 32. Continuing our coverage of the elections for 2018, and joining me now via Skype from Albuquerque is candidate for New Mexico Court of Appeals, Position 2, Jacqueline Medina is joining us by Skype. And Ms. Medina, good morning. Thank you for being with us.
Good morning. Thank you for having me.
You bet. I appreciate you being available to talk to our listeners and viewers as we are streaming the program on Facebook and YouTube. And talk to me a little bit about why you decided to run for the New Mexico Court of Appeals.
There were a couple of reasons I decided to run.
Okay.
Well, I've been an attorney for 27 years, and for 16 and a half years, I was an appellate attorney in the Attorney General's office. I handled, 1 year I handled administrative appeals in the district courts and then followed them up to our New Mexico Supreme Court. And then I also had 16 and a half years adjacent with that, handling the criminal appeals where I prepared the appellate arguments in the New Mexico Supreme Court and Court of Appeals. I handled over 160 of them, and those were from criminal cases. And the New Mexico Court of Appeals, there are many people out there, if they're not familiar with this court, it's a 10-judge court for the entire state, and it's a review court that sits right below the New Mexico Supreme Court. So parties that appear in front of the Court of Appeals do not relitigate their cases. They don't present new evidence or forms of testimony or documents. What happens in most cases when a party is unhappy with a ruling from the district court, whether it's criminal or civil, child custody matter, a variety of cases, or they believe that there was an error in the process, their attorneys can file an appeal to the Court of Appeals claiming this is what went wrong in the court below. We'd like you to look at it and reverse the ruling or reverse the conviction. And the Court of Appeals will either summarily dismiss the case or decide it because there's already established law directly on point, or they'll assign it to the general calendar. And when the Court of Appeals assigns a case to the general calendar, that case, those issues the party is raising, will be assigned randomly to 3 of the 10 attorneys on this court. And those attorneys will then review the written arguments, which are submitted in the forms of written briefs, and review the arguments by both parties, and most often then issue a written decision. If it's a formal opinion, they refer to it as an opinion to the parties with their decision. Sometimes, though, the court, the 3 judges on the panel, will find it necessary to call the parties into the courtroom for what's called an oral argument. And when that takes place, attorneys for each side of the case are given 30 minutes to present their oral arguments to the panel of 3 judges who can ask questions during the presentation about the issues or the legal authority that they had questions about that the parties are relying on. And in those instances, then later the three judges will then issue an opinion. Sometimes you will receive a written opinion where two of the judges, and that would be the majority, were in agreement with the result, and you have one who dissents and disagrees. But you do need a majority result for the opinion. And if the parties are still unhappy with the way the Court of Appeals ruled on their case, their attorneys can petition the New Mexico Supreme Court for discretionary review and to look at the case again. And if the Supreme Court grants discretionary review, the process starts again. The parties then resubmit new briefs to the court, the New Mexico Supreme Court. So that's the type of law I practiced for 16 and a half years. Right. I was arguing and presenting claims to the New Mexico Supreme Court and the Court of Appeals. And when I was getting ready to retire from the Attorney General's office, two judges from the 10-judge court retired. So there were two spots that were opened. And colleagues from the Attorney General's office and the New Mexico Public Defender's office actually asked me to consider applying for these positions because 40%, the largest percentage of cases that the Court of Appeals hears, come from criminal cases across the state of New Mexico. And historically, you do not see experienced attorneys with extensive criminal law background applying for positions or running for positions on the New Mexico Court of Appeals. You have some judges sitting on the Court of Appeals who have had a combination, but the majority of them tend to come from civil backgrounds, yet the majority of cases are criminal in nature. So I was asked to consider this position, and it's something that I wanted to do. I gave 25 years of my career to public service, and I wasn't ready to stop. So I thought, I acquired extensive appellate experience and trial experience when I worked as a prosecutor. Why not continue? I think I have a background to contribute to this court.
Right. But again, it seems a little different, I think, to see candidates running for a judgeship having to run a political campaign, because this is something of a novelty, because usually judges are just retained, but in certain situations where there's a vacancy, you do have to run in an election the first time. Isn't that how this has happened?
That's correct. And that's a question I get often as I've been traveling the state, presenting myself as a candidate. So in New Mexico, we have a hybrid system. So when a judge decides to retire from a court, you can go before a bipartisan judicial nominating commission if you've been practicing the requisite number of years. And it's a vetting process. It's a very extensive vetting process that goes into detail. The commission wants to know not only how many years have you been practicing, but what areas of law, what areas have you practiced in criminal law, civil law, bankruptcy, children's court. And then it's broken down even further. They want to know how many trials have you presented to the bench, just to a judge without a jury? How many trials have you presented to a jury where you lead counsel? How many appellate briefs did you write? How many oral arguments have you written? What kind of activities do you engage in outside of your legal career? And after you submit this lengthy application, you then go before this commission, and it consists of 7 Republicans and 7 Democrats. And each participant in the commission gets to ask the applicant one question. And so all the attorneys who go in one by one before the commission are vetted in this process. And not every attorney, sometimes they are, but in certain judicial commission interviews, not every attorney who goes before this commission will be deemed qualified and recommended. But I went before this commission twice, and each time they qualified me and recommended me to the governor for a possible appointment to fill the vacancy on the Court of Appeals. Now, each time she decided to pick 2 other men instead of myself, and as is the case in our process, once the governor appoints a judge to fill a vacancy on a court, that judge has to run in a contested race, the next contested race, in order to hold on to their bench. And so our system in New Mexico, it has an appointment process, but it also gives the voters of New Mexico the ultimate say in whose background or which candidate they want to see representing them on the court.
You bet. And it's an interesting system, I think, and certainly we want more public participation, I think, in the process. Would you agree?
I'm in favor of having the public participate in the process because it gives the public access to the candidate's background and allows them to make that choice.
Sure.
And if the public sees that the candidate has been qualified by the nominating commission, then they have that extra sense of security to know that at least the candidate has been vetted and deemed qualified.
Right. But it also puts you in the position where I know there are perhaps some questions that you prefer not to talk about, or some legal cases that we certainly can't maybe get into in the course of an interview. I could certainly ask you how you feel about certain things in the law, but you're kind of limited as to what you can really talk about publicly, wanting to be any type of a judge. Isn't that true?
That's absolutely true. And it's a common question. I noticed, again, campaigning across the state, that the voters, they want to know where you stand on an issue. And when I explain to them as a judicial candidate, I can't tell them and that they should actually just look at my background and base their vote on my background or that of my candidates, they tend to understand. Because if you have a case that you want to bring before the court, and you had a judge on the panel who already announced his or her position on a certain issue that might be involved in your case, would you want that judge sitting on the panel on your case if they've already prejudged it and announced it? You want a judge who's going to apply the law to the facts of the case that are presented. And in appellate practice, an issue that's brought before the Court of Appeals has to be preserved. It has to be in the record already. You can't bring up a new issue. And so the judges on the Court of Appeals apply the law to the facts that are presented in the record that was developed below, for example, in the district court proceeding, whether it was a child custody case or a criminal prosecution case, a suppression hearing, a variety of cases, a property issue.
Sure. And maybe I can ask you, though, that when a case does come before the Court of Appeals, I imagine a lot of the judges on the panel will pay attention to the precedents of that case. They'll pay attention to maybe what the ruling was at the district court level, and are you looking for maybe something that the lower judge did maybe incorrectly, maybe some jury instructions or things like that, or problems with the law, because that certainly would have to get kicked back to the legislature, I suppose, if that's the case, right?
Well, actually, that's an excellent question. So it goes actually to the process of how the appeal gets before the court and the issues are raised, and the variety of issues that can be raised by the parties. So, for example, having practiced appellate law for 16 and a half years, it was not uncommon for me to receive a case where a party was claiming a jury instruction that was submitted to the jury was incorrect, or that the judge interpreted a statute incorrectly. And so my process as the attorney to assist the court was to review the entire record. I would listen to the motion hearing or read it if it was transcribed. I would research the statute or the jury instruction and look at how the judge ruled. But I also had to pay careful attention to what the two attorneys argued to the court, because if an attorney wants to assert that a judge interpreted a statute incorrectly to the Court of Appeals, that attorney has to actually make that argument in the district court so that they can alert the district court that they might be ruling incorrectly. Otherwise, a district court judge would be sandbagged if they hadn't been alerted that they're interpreting the statute incorrectly. And that's what's known as preservation. You must preserve the claim of error below in the trial court before you can assert it in the Court of Appeals. And so to the extent that you pay attention to the ruling of the judge, you do that, but you also listen to what arguments were made to the judge verbally and sometimes in writing to ensure that there was issue preservation. If there was no issue preservation in the court below, then the Court of Appeals can't review that issue. And it's not uncommon for parties in the appellate process to argue they can't raise this issue, they didn't preserve it below.
I see. Interesting. But it goes to show kind of the very detail that you're really looking at that level of the judicial process, right? That you're really looking at these previous rulings, these previous cases, and really trying to pick apart what may or may not have gone right or gone wrong, I suppose, if you get an appeal.
Absolutely. The best way I can describe it is that it's combing the record with a fine-tooth comb.
Right.
And equally looking at prior case precedent that you brought up and reading those cases with a fine-tooth comb and determining whether those prior precedential cases can be distinguished from the case you're working on so as to show the court this case doesn't really apply or control here, or to argue that it does control. Because even though there might be differences, they're differences without a distinction.
Right.
But it takes, it's a process that takes patience, and you have to be an attorney who pays attention to detail. Many times it's fine details in the record that are going to either support your case or not.
Understood. Well, Jacqueline Medina, we are running out of time this morning for our conversation. I'm so sorry, but I do appreciate you taking the time to connect with us again via Skype and to appear on the program this morning. If folks would like to find out more information about you and your campaign, how's the best way to do that?
Well, there's two places you can check, and one is medinafornewmexico.com, or if you have a Facebook account, Jacqueline Medina for New Mexico also has a Facebook campaign page. It's not run by myself, it's run by my campaign manager, but you can send messages or get in contact with us. The web page also has a phone number and ability for you to contact us by email if you have questions or you want more information, which I encourage the voters out there to do if they have any questions for me.
All right. Very good. Well, again, thank you for your time. We are out of time on this segment, but thank you so much.
Thank you for having me.
You're very welcome. That's Jacqueline Medina. She is a candidate for New Mexico Court of Appeals, coming up in the election, of course, in November. And I'm Scott Michlin. I'll be back with more in just a moment right here on KSJE.